Welcome to the Sir Frank Kitto lecture. It's 2024, of course, and it's been going for a long time. Tonight, we have the honour of having Professor Ben Saul, who's going to give us a lecture on the international law after Ukraine and Gaza. So I'd like to call on the Deputy Vice-Chancellor to do acknowledgement of country and an introduction.
Thank you, Kip. Can I welcome everyone here tonight and begin by acknowledging we're meeting on the unceded lands of Yanoan people, pay respect to them and their elders, and to the elders of the Dungati, the Gomeroi and the Gamilaroi people with whom they share the custodianship of this land, and all the traditional owners across Australia on whose lands people are joining us tonight via Zoom. Tonight, it is my great privilege to introduce Professor Ben Saul to deliver the 2024 Sir Frank Kitto lecture titled International Law After Ukraine and Gaza. Before we get to Ben, let me say, as a recovering constitutional lawyer, what a pleasure it is to introduce an event in honour of Sir Frank at UNE, which his name is spelt out in full. I spent my first year or so at UNE puzzling down at the colleges what this SFK competition was. So Frank has been embedded in the fabric of this institution and memorialised by the colleges naming the intercollegiate non-sporting competitions, the SFK. I do wonder whether any of the other judges of the Justice of the High Court have been remembered after retirement as SAM or SGB. I don't think so. It's wonderful to be here. It's wonderful to welcome Ben to give his lecture. Professor Ben Saul is the Challis Chair of International Law at the University of Sydney, where he sits in a very distinguished line of international lawyers, including James Crawford, late Justice of the International Court of Justice, Gillian Triggs, Human Rights Commissioner in Australia, Don Rothwell, a name not so storied, but one who I will remember forever as my Jessup coach when I was a young law student trying my hand at international law mooting competitions. And I won't forget James Crawford driving us home from a practice moot, conducting Mahler's Second Symphony with one hand while driving down George Street, his hand on the wheel and the other. So Ben lies in a distinguished and colourful line of Challis professors of international law. He's also the United Nations Special Rapporteur on the promotion and protection of human rights and fundamental freedoms while countering terrorism. No small order, that brief. I think you will agree. He's published 20 books and hundreds of scholarly articles, including the books Defining Terrorism in International Law, the Oxford Commentary on the International Covenant on Economic, Social and Cultural Rights, which was awarded a Certificate of Merit by the American Society of International Law, a research handbook on international law and terrorism, and the Oxford Guide to International Humanitarian Law. I think in that short list of publications, you can see the distinguished qualifications he brings to his current role with the UN. Ben has taught at Oxford, Harvard, The Hague and Sharman Academies of International Law and in Europe and Asia. He's practiced in international tribunals, advised governments, NGOs and the UN, worked in over 35 countries, only 170 or so to go, and appeared regularly in the international media. He's an elected Fellow of the Australian Academy of Social Sciences and formerly an Associate Fellow of the Royal Institute of International Affairs, Chatham House in London, and the International Centre for Counter-Terrorism in The Hague. It is therefore a distinct pleasure and honour to invite Ben Saul to deliver the 2024 Sir Frank Kitto Lecture at UNE.
Thanks so much, Simon. And I just have to drop this because you're a lot taller than I am. Good evening. I also acknowledge the traditional owners. It's my honour to be invited tonight to deliver this year's Sir Frank Kitto Lecture. I was pleased to learn that Sir Frank had strong connections to both of our universities. Early in his career, he was a Challis lecturer in law at Sydney, a bequest which supports my own position still today. In the 1930s, and then 40 years later became Chancellor of the University of New England here after retiring from the High Court in 1970. He also received honorary doctorates from both of our universities. Institutionally, there are also strong historical links between our two universities. In 1935, the governing Senate of the University of Sydney, on which I'm currently an elected fellow, wisely agreed to open what became the affiliated New England University College. Its first warden, Dr. Edgar Booth, insisted that students and lecturers eat together at all meals. I'm not sure today whether this would be a recipe for greater or lesser student satisfaction with their university experience. My own family has a meaningful connection with this university. My sister lived here in college as a student about 30 years ago on campus, coming from another part of rural New South Wales. She was the first member of my family to attend university in the 220 years that our family have lived on this continent. And as a teenager, I remember being awed by her graduation ceremony on the front lawn of the beautiful National Trust listed, and I'm hoping I pronounce this the right way, Buluminbar House. I think that's a fair impression. At the time, it prompted me to imagine what opportunities studying at a university might unlock for a kid like me from an ordinary family in the bush, a journey which eventually led me to Sydney University and then Oxford, Harvard, and now the United Nations. Regional universities like UNE play a vital role in expanding equitable access to higher education and through it in expanding life opportunities, from intellectual growth to lifelong connections to people to fulfilling career aspirations. As a professor of international law and a United Nations Special Rapporteur, I spend my professional life thinking about applying and critiquing international law. There are traces of it even in Buluminbar House. The stained glassed so-called Gordon window sitting above the main staircase depicts the lionized death of the Victorian-era general Charles Gordon at the Battle of Khartoum in 1885, a place currently racked by warfare yet again. Gordon fought in the Crimean War, the Taipei Rebellion, the war in Sudan, and even demarcated the border between the Russian and Ottoman empires. He lived in a different international legal world where the use of military force to colonize foreign territory was lawful. Constraints on war fighting were relatively primitive, and human rights law, as we know it today, had not been invented. He was inevitably a creature of his time, which was nonetheless a time of contradictions. On the one hand, he was an agent of the colonial civilizing mission. On the other hand, he was personally known for his humanitarian efforts to spare prisoners of war in in China, to abolish the slave trade in Egypt, to ban public floggings in Sudan, to evacuate civilians from besieged areas. He fought corruption and he fought to recognize the humanity of Africans and Chinese subject to foreign intervention, all early human rights work. Tonight, I'd like to talk about some of the modern-day contradictions in the international legal order that applies to the current wars in Ukraine and Russia and Israel and Palestine. I declare up front that I'm subject to sanctions from the Russian government, so I may not be the most impartial observer. It speaks volumes about the paranoia and dysfunction of the Russian state, that a distant Australian academic is considered a threat to Russian national security, up there with F-16s and Bushmasters. My 6-year-old recently imagined Putin was flushed down a supersized toilet along with Donald Trump, perhaps a more effective solution for world peace than what the current international order offers. Now, I've been asked to go for about an hour. I hope your attention span lasts that long. My son's lasts for a 7-minute Bluey episode, but we'll see how we go. Firstly, on Ukraine and Russia. Russia's full throttle invasion of Ukraine in the last 2 years is so shocking because it is such a brazen assault on the post-1945 world order, an attempt to extinguish and cannibalize an independent neighboring country. It's tempting to view Russia's aggression as the death knell of international law's ban on war and a return to the pre-modern law of the jungle. A permanent member of the UN Security Council, responsible for maintaining world peace under the UN Charter, is seeking to rebuild an empire by using overwhelming, indiscriminate, and barbaric force. In historical perspective, I think that view is too pessimistic. Russia's aggression is a rare exception to the rule against war that holds fast in most places, most of the time, occasional crises notwithstanding. Even the influential realist Hans Morgenthau acknowledged that compliance with international law is the norm. Quote, "The great majority of rules of international law are generally unaffected by the weakness of its system of enforcement, for voluntary compliance prevents the problem of enforcement from arising altogether." The problem of enforcement becomes acute, however, in that minority of important and spectacular cases in which compliance and enforcement have a direct bearing on the relative power of the nations concerned. In those cases, like the use of force, considerations of power rather than law determine compliance and enforcement. Even so, to my mind, international wars occurred on average every year. So international, I mean interstate, as we'd know them today, occurred every year from the Middle Ages through to 1945. For many centuries, war was a common and lawful tool, whether for colonizing land or seizing resources, enslaving peoples, punishing enemies, or inflicting religious dogma. Now, international wars are very rare. In part, this is why they are so confronting when they occur, particularly on a scale such as this, by actors such as this. The world, now a relatively stable community of 193 independent countries, is no longer a shifting mosaic of empires and colonies that changed their shape from year to year. War was first outlawed as an instrument of foreign policy by the Kellogg-Briand Pact in 1928, but it failed to stem the fascist and militarist aggression that consumed the globe during the Second World War. A more comprehensive ban was placed at the heart of the United Nations Charter in 1945, with the exception of national self-defense and collective security by the Security Council itself, after a truly global war, which killed perhaps, we don't know, 60 to 80 million people, probably 50 million of them civilians. This new architecture was backed by the binding enforcement powers of the UN Security Council, which were lacking in its predecessor, the League of Nations. All the great powers were also included in the UN tent, unlike at the League, where powerful non-member states ran amok, including fascist Germany and Italy, militarist Japan, the communist Soviet Union. Respect for the sovereignty, territorial integrity, political independence of other countries is the legal and moral foundation of the long relative peace that the world has enjoyed for the past 75 years. And along with decolonization, it has fundamentally transformed the international order from what had gone before. Now, of course, historical perspective is cold comfort to Ukraine under fire today. What is more encouraging is the effort by large parts of the international community to enforce international law against Russia, using the wide range of legal tools available. What matters is how the legal system responds to violations. In the absence of any global police or universal enforcement machinery, international law is implemented in a decentralized way at international, regional, and national legal levels through administrative and judicial measures and social processes, and involving a range of actors from states to NGOs to corporations. The methods of compliance, the number of courts, the mechanisms available have proliferated over the last 75 years since the Great Second War. Compliance is often impelled by voluntary consent by states to treaties, inducements and incentives, persuasion, sanctions, socialization amongst peers, amongst many other processes. In the case of Russia, Russia has been repeatedly condemned for aggression by 3/4 of the world's states at the United Nations General Assembly, which provides a good barometer of global legal opinion. The world has rejected Russia's spurious justifications for war, including that it's countering genocide or Nazism in Ukraine, protecting Russian nationals there, or the separatist republics, or preventing somehow NATO aggression. The UN has also suspended Russia from the UN Human Rights Council. It's also suspended from the Council of Europe. The General Assembly has demanded Russia pay reparations for the vast damage it's caused. Multiple cases are underway at the International Court of Justice. There are 10 cases at the European Court of Human Rights. The International Criminal Court and a UN Commission of Inquiry are investigating international crimes and violations of human rights. All of these steps delegitimize and isolate Russia, even if alone they cannot compel Russia to withdraw. There's also been a swift and effective humanitarian and refugee response, unlike perhaps what we see in Sudan and some other places, and efforts to stabilise agricultural exports and world food security. At the national level, Russia has been met with heavy economic sanctions, which have inflicted significant stress on the Russian economy and disrupted the replenishment of its war machine. Added to this is voluntary divestment, pursuant to the business and human rights movement, from the Russian economy by many large international companies. War crimes investigations are underway at the national level in Ukraine and with foreign cooperation in various other foreign courts from Europe to beyond. Most pointedly, Ukraine's international legal right of self-defense is undoubted. It includes the right to request foreign assistance to repel Russia's invasion. And many Western states have heeded the call by lawfully providing heavy military weapons, ammunition, intelligence on Russian targets. Australia has provided over $1.1 billion in military assistance, making it the 17th largest contributor, or 27th by GDP, which doesn't look quite so impressive. Recall that Australia is the world's 13th largest economy. But all of this international military assistance has assisted Ukraine to weather Russia's attack. The extraordinary, almost textbook legal response to Russian aggression is not disproportionate or undeserved, but well justified by the scale of the crisis. Great power aggression to conquer territory, 1/3 of Ukraine's population of almost 40 million displaced from their homes at some point, 5 million refugees abroad, 15 million people in need of humanitarian assistance, at least 35,000 civilians killed or injured, and the real number is much higher than that. Ukrainian military casualties in just 2 years are at least as high as the 58,000 Americans who died in 2 decades in the Vietnam War, or the 69,000 Afghan security forces killed in the 2 decades after 9/11. Well over 100,000 Ukrainian soldiers are wounded. Russian casualties number a staggering 400,000 to 700,000 people killed or injured. Now, that more is not being done is largely a political, not a legal problem. Only about 29 countries have provided any military aid to Ukraine at all, about 15% of the world's countries. The law, international law, allows foreign countries to throw their own forces into battle against Russia, but no one is willing to do it. Unlike in the first Gulf War, when a US-led coalition, including Australia, repelled Iraq's occupation of Kuwait. Nuclear weapons are not universally banned under international law. As long as they exist, they will powerfully deter those contemplating using force against states that possess them, although views differ on whether Russia would really use them and risk the likely destruction of Putin's own regime. Australia, too, is not amongst the 160 countries that have signed a 2017 treaty to ban them completely. And we rely on the US nuclear umbrella for our defence, which paradoxically might make us more insecure. There's also little appetite after Iraq and Afghanistan to put boots on the ground in foreign wars at all. The tension in the UN collective security system since 1945 is that it relies on a vision of international solidarity, that law-abiding and peace-loving countries will come to the mutual defence of any threatened country, not only close allies, like under a treaty such as ANZUS. It also asks a lot. Why should a single Australian die to save Ukrainians from Russia if it doesn't concern Australia's direct national interests? Would any of us here tonight seriously consider volunteering to fight in Ukraine to die for Ukrainians? Or in an even worse conflict, would any of us go to Sudan to stop the bloodshed there today? One answer is that all countries have a core national interest in mutual self-defence. If the rainy day ever comes when we ourselves are threatened, and hope that someone answers our call for help, particularly if the US someday cannot be relied upon. Collective self-defence is also about deterrence. We can't defend, we didn't defend Ukraine in 2014 when Russia swallowed Crimea, and look what happened next. The weaker the legal order becomes, the greater the risk of lawlessness becoming contagious and the order we take for granted, the 75 years of long peace, unravelling before our eyes. Maintaining peace against predatory states is a burden all countries must share, particularly those with the greatest resources. Sanctions not being stronger or broader against Russia is likewise due to the thresholds of economic and political pain that Western governments are willing to bear, not due to any legal limits. Only about 45 countries, that's maybe a quarter of the world, have imposed any form of sanctions on Russia. It's troubling that most non-Western states throughout Asia, Africa, and Latin America, a global majority, are not willing to impose any sanctions on Russia. These notably include large democracies like India, Bangladesh, Mexico, Brazil, and South Africa. Some are even taking advantage of cut-price Russian oil and gas deals, undermining the sanctions of others, or are otherwise prioritising their military or trade links with Russia. Fewer than 100 states voted in the General Assembly to suspend Russia from the UN Human Rights Council or to affirm Russia's duty to pay compensation for the damage it caused by aggressively invading another country. These countries erode the capacity of international law to credibly constrain aggressors. They also freeload off the international security system, expecting to benefit from the ban on military force without shouldering any burden to maintain it. Simply calling for negotiations, as some of these states do, is also unconscionable, since this inevitably expects the victim of aggression to make concessions, territorial or otherwise, to the aggressor in violation of international law. The modern law insists that Ukraine should not be pressured to give an inch of its territory. The Security Council's paralysis due to Russia's veto does not in any way preclude the right of countries to collectively defend Ukraine or unilaterally impose sanctions. To be sure, the veto is a curse, but in its historical perspective, it was also a blessing, giving the permanent five, the big powers at the end of the war, the discretion to act or to block action by the Council was the price the world had to pay for the great powers to agree not only to be part of the UN at all, but also to agree to be responsible for providing and financing and giving the soldiers to guarantee the global public good of peace and security. The selective provision or failure to provide security, nonetheless, evidently damages international law's legitimacy in large swathes of the world. But having no entity capable of ever providing global security would, of course, be far worse. It's hard to imagine the great powers willingly surrendering their veto in our lifetime, absent some seismic event like a world war. They should be scorned whenever they arbitrarily exercise their veto and shamed into more faithfully discharging their responsibilities. Sadly, there's also no legal prospect of removing Russia from the Security Council, as some have suggested. The world has also failed to create a much-discussed special tribunal to prosecute Putin and other senior leaders for the international crime of aggression. The ghost of the Iraq War in 2003 looms large. Recall that the United Kingdom Attorney General at the time advised the UK government that the invasion could constitute the international crime of aggression, the same crime for which we executed German and Japanese leaders after the Second World War. Some Western states are uneasy about criminal liability for aggression, Australia too has not signed the amendment to the International Criminal Court statute, which would make aggression a crime for those states that accept it. While Putin is rightly seen as a pariah for committing aggression in Ukraine, Western leaders like Bush, Blair and Howard are feted as benign elder statesmen. Many states from the global south rightly see double standards in judging Russia for aggression, but not the West or currently Israel for their own violations, and are reluctant to commit to selective enforcement. This also helps to explain why many states outside the West in general are less committed to Ukraine's cause than we are. Legal solidarity with Ukraine is just and necessary, and more should be done by more countries. Yet the relatively muscular international response to Russia exposes Western self-interest and double standards in not enforcing international law in other grave situations. Engaging in whataboutism is not a cheap rhetorical deflection of criticism of Russia. Western disrespect for international law has influenced Russia's belief that power trumps law, as well as the view of many non-Western states that they should put immediate self-interest ahead of enforcing the law against violators like Russia. The US-led invasion of Iraq in 2003 was a dagger to the heart of the most fundamental rule of world order since 1945, that military force must not be used against another state except in self-defense. It was backed it was led by the US, backed by another member of the Security Council, the United Kingdom, and backed, of course, by Australia. It followed the earlier lawless shock of NATO's humanitarian intervention in Kosovo in 1999, leading ultimately to its forcible separation from Yugoslav sovereignty. These rule-breaking precedents and the impunity that followed reverberated and reverberates from Moscow to Beijing and beyond. There are many other stark examples where the West or its allies have used, encouraged, or tolerated illegal military force. Just as Russia has illegally annexed Crimea, Morocco has purported to annex Western Sahara since 1975. Israel has annexed East Jerusalem and Syria's Golan Heights. The United Kingdom maintains illegal colonial rule over Mauritius's Chagos Islands. The International Court of Justice has ruled all of these situations illegal, yet the United States has accepted the claims of the states acting illegally to all of those territories for self-serving security or political reasons. Just last month, France, during the supposed Olympic truce, endorsed Morocco's autonomy plan to annex Western Sahara and retain sovereignty, purported sovereignty over it, in violation of the Sahrawi right of self-determination declared by the International Court of Justice many years ago, and the prohibition on acquiring territory by military force. For more than 2 decades, to go back in history, Australia recognised Indonesia's illegal annexation of East Timor until it was forced by a humanitarian crisis on our doorstep to return to the fold of international law. Even then, it refused to recognise Timor's rightful maritime claims for many years. It convicted one person and attempted to prosecute another for exposing Australian economic cheating in the resource negotiations with one of the world's poorest countries. In the global war on terror, something I work on every day, the United States has used military force, from drones to special forces, in dubious legal circumstances on many occasions in many countries. In recent years, Western states have not protested as Israel has conducted over 400 so-called preventive military strikes on Hezbollah targets in Syria, none of which, in the absence of any armed attack on Israel by Hezbollah from Syria, is justified as lawful self-defense. Israel itself has not claimed it as self-defense or reported it as self-defense to the Security Council as required under the UN Charter. While Saudi Arabia was rightly lambasted for assassinating journalist Jamal Khashoggi in a consulate in Turkey, there has scarcely been a murmur as Israel conducted 6 separate assassinations of Iranian scientists, not lawful military targets, in the past decade. These are examples of Western hypocrisy just in relation to the prohibition on military force or acquiring territory by force, and then only in recent memory. The legacy of illegal Western violence during the Cold War and the decolonisation period is still remembered in the global South. And I talk to these ambassadors every week and can tell you this history still resonates. Whether we think of coups and interventions in Latin America and elsewhere, napalm and Agent Orange in Vietnam or Cambodia, carpet bombing in Laos and Cambodia, as Russia threatens to use nuclear weapons, recall that the United States is the only country to ever have actually used them to deliberately kill large numbers of civilians to force Japan to surrender. I will never forget meeting a survivor from Hiroshima who was a young girl in 1945 who described the horror of seeing her own skin hanging in shreds from her body. There are also flagrant recent Western violations of other fundamental international rules like human rights and humanitarian law. During the war on terror, bearing in mind the anniversary of 9/11 yesterday, the US government abducted, tortured, indefinitely detained, unfairly tried, and even murdered terror suspects and civilians. Accountability 23 years later is largely absent. Given its global preeminence, US impunity signals to other countries that lawlessness and international crimes are acceptable when countering terrorism. That signal continues to be acted upon around the world, including by US allies. In Afghanistan, American, British, and Australian suspected war crimes against civilians, also in Iraq, have so far largely gone unpunished. Australia, to its great credit, is taking the problem more seriously than some of those other countries by prosecuting or trying to prosecute in relation to at least 39 murders exposed by the Brereton inquiry, although it has still failed to compensate the victims' families made destitute by the loss of their breadwinners in impoverished Afghanistan. Just last month, I took a case against Australia at the UN where one of the victims murdered by Australian Special Forces had 17 children depending upon him. They don't go to school, they don't wear shoes, they've had nothing for 10 years from the Australian government, who haven't even contacted them or sought to apologise to them, let alone compensate them for their losses. The United States, United Kingdom and France continued to sell weapons to Saudi Arabia despite it committing war crimes in Yemen. Sri Lanka is Australia's valued partner in countering people smuggling and interdicting asylum seekers despite total impunity for Sri Lankan war crimes, perhaps tens of thousands murdered in the final months against the Tamil Tigers in the 25-year civil war that ended in 2009. The United States has shown similar hostility to international accountability that Russia is showing now. The US has long opposed and actively undermined the International Criminal Court, including imposing sanctions on it. It withdrew entirely from the International Court of Justice, the World Court under the UN Charter, when it lost a case to Nicaragua in 1986, after the court found the US had been illegally using military force against a democracy. It routinely condemns the United Nations for daring to criticise it or its allies. The United States comes second only to Russia in the most vetoes of Security Council resolutions, far ahead of China. An exceptionalist United States refuses to become a party to many of the world's most basic and widely subscribed human rights treaties, including on the rights of women, children, people with disabilities, and migrant workers, and against enforced disappearances. It's not a party to the canonical Treaty on Economic, Social, and Cultural Rights, which are the most basic things like rights to food, healthcare, education, water, sanitation, etc. It also refuses to sign treaties banning terrible weapons like landmines and cluster munitions. It even gave cluster munitions to Ukraine in recent times. It will not even join the quasi-constitutional Convention on the Law of the Sea, despite condemning China for violating that treaty, and rightly condemning China, by the way, in the South China Sea. It extols free trade, but has crippled the World Trade Organization appeals system by vetoing the appointment of new appeals judges. This brings me to talk about the current, but really century-long conflict in Israel and Palestine. That catastrophic intergenerational conflict draws together, I think, many of the threads above that I've talked about in a kind of totemic example of Western hypocrisy and the dysfunction, but also the tantalizing promise of international law. The dispute, as I mentioned, has gone for at least a century. The latest violence since Hamas's attacks on 7 October are particularly horrific, both in their methods and the scale of suffering. I mean, Hamas killed over 1,200 Israelis and foreigners, wounded 3,000, took 250 hostages, has murdered many of them. The attack involved apparent war crimes under international law, such as murder, attacking civilians, hostage-taking, arbitrary detention, torture, mutilation, sexual violence, in addition to the long-standing tactic of indiscriminate rocket fire against civilians, clearly prohibited by international humanitarian law. Some of these acts would also probably qualify as crimes against humanity. Some people talk about Hamas as a terrorist organization or committing terrorism. To my mind, terrorism is a crime under national law. There is no international crime of terrorism. War crimes and crimes against humanity are crimes of universal jurisdiction. They're the worst thing the world has labeled as the most egregious forms of criminality. And Hamas has certainly committed many of those. The Israeli response has killed 40,000 people, a majority, at least civilians, including 14,000 children. It's made many more children, many children limbless, amputees as well. It's injured over 100,000. It's damaged about 70% of Gaza's housing and decimated most public infrastructure, including hospitals, schools, water, sanitation, food systems, as well as businesses. Rebuilding Gaza will cost probably, latest estimate, more than $80 billion. It's clear, and I've been watching this closely in my UN role for the last 10 months or so, it's clear to me that Israel has not taken the level of care required by international law to spare civilians, even accounting for Hamas's own tactics, urban warfare, tunnels, which of course endanger civilians and violate Hamas's own obligations under international humanitarian law. There is abundant, credible evidence documented by the UN and others of alleged Israeli violations of international humanitarian law and crimes against humanity. Some of these have been charged already. The prosecutor of the International Criminal Court is seeking charges from the court for an indictment. Violations include denial of humanitarian relief and starvation and extermination of civilians, murder and deliberate attacks on civilians, indiscriminate and disproportionate attacks on civilians, including through the use of high explosive weapons in densely populated urban areas, willfully causing great suffering and cruel treatment, persecution, and what are called other inhumane acts. On top of this, Israel has failed to fulfill its governance and law and order obligations as the occupying power in Gaza. The International Court of Justice just last month found that Gaza is indeed occupied by Israel. In the occupied West Bank, there has been increasing settler and military violence. In total, almost 10,000 Palestinians are held in Israeli prisons or ad hoc military facilities, many arbitrarily detained, with over 50 people having died due to inhumane conditions. Some of the pictures coming out of the military detention facilities look like Abu Ghraib in those early days of the US war on terror. Now, as in relation to the war in Ukraine, in one sense, there has been an impressive mobilisation of international legal tools to address these violations. The International Criminal Court has sought arrest warrants for Hamas and Israeli leaders. States have sought to halt alleged genocide at the International Court of Justice, so the other court, securing provisional measures. The Security Council has demanded a ceasefire, which was not sadly respected. It has sought to facilitate more humanitarian relief. National legal procedures in various countries have halted arms exports to Israel, given the clear risk of their use in violation of international humanitarian law. A good example being a Dutch appeals court banned the Netherlands, and the Netherlands has complied, from exporting F-35 fighter jet parts to Israel because of the way those jets are being used. There's in addition, an appreciable groundswell of public sympathy in many countries for the victims on both sides, and mobilisation of social protest movements against violations, despite, I'd have to say, some intense media partisanship and political polarisation in some countries. Yet there are also many differences from the Western response to Ukraine. Despite some criticism of Israel's conduct of the war, the US has remained steadfast as Israel's protector-in-chief. Along with Germany, it continues to export 99% of the weapons imported by Israel. It continues to provide military aid, despite manifest violations of humanitarian law. It largely shields Israel from serious criticism or real action by the Security Council, as it has largely done for the past 75 years. It's refused to impose sanctions, in contrast to the Russia example, with the exception of sanctions on a few extremist settlers in the West Bank. It opposes the International Criminal Court investigation, despite sharing information with the court to put Russia in the dock. Some US political leaders have even made serious threats against the court if the court confirms the charges sought by the prosecutor. The US has largely ignored the authoritative findings of successive advisory opinions of the International Court of Justice, on which sits, of course, nowadays one of Australia's most preeminent international lawyers, my friend and colleague, Professor Hilary Charlesworth. The US's criticism of illegal settlements, and it has made the criticism, is generally muted or most commonly without consequence. The numbers of settlers have ballooned in the last decade. We're now at 700,000 settlers in the West Bank. The US supports a politically negotiated settlement, pursuant supposedly to the Oslo Accords, but does so without adequate regard for the red lines imposed by international law to structure any principled negotiations, bearing in mind that negotiations would be between grossly unequal parties, only one of whom is supported in a highly unequal and partisan manner by the United States. Domestically, new McCarthyism against overwhelmingly peaceful Palestinian protest and legitimate speech critical of Israel has taken hold in some quarters, including some university campuses, which is a disproportionate reaction to the sporadic incidents of what are, in some cases, awful cases of anti-Semitism, hate speech, and so on, that have undoubtedly occurred not only in the US, but in Australia and elsewhere. The current cycle of violence is just one small part of the century of conflict. As the UN Secretary General correctly stated, Hamas's attack, quote, did not happen in a vacuum. It is obviously connected with long-standing and often legitimate Palestinian grievances. The United Nations Global Counter-Terrorism Strategy, in force today, adopted in 2006, was adopted by consensus by all states in the international community, including Israel. It urges all countries to address what in UN jargon are called the conditions conducive to the spread of terrorism, what in the old days we called the root causes of terrorism. The strategy says those conditions include, quote, prolonged unresolved conflicts, dehumanization of victims, lack of rule of law, violations of human rights, ethnic, national and religious discrimination, political exclusion, socioeconomic marginalization and lack of good governance. Almost all of these factors are present in Israeli-occupied Palestine and have been for many decades. The global strategy declares that conditions conducive to terrorism cannot excuse or justify terrorism, but they must be addressed. They are not deterministic root causes. People ultimately choose to resort to violence and they choose the methods of violence. But they are not irrelevant to diffusing the violence that arises. In July this year, the International Court of Justice advisory opinion on essentially on the lawfulness of Israel's occupation identifies precisely some of these causes underlying the present conflict. I'll just list the main findings: illegal annexation of Palestinian territory in violation of the international prohibition on the acquisition of territory by force, what Russia is doing in Ukraine. Denial of the right of self-determination, the right to freely choose your political future, govern your own territory, have your own state. Violations of the law of occupation and human rights law, including three key ones: illegal settlements, which the court said Israel must evacuate; illegal exploitation of natural resources belonging to Israel, as belonging to Palestinians, so that Israelis, both in the settlements and in Israel proper, profit from those resources; illegal land confiscations and evictions, denying livelihood, subsistence to Palestinians, with a duty to return that land and to allow displaced Palestinians to return home, and a violation of the prohibition. And this is where they got a bit ambiguous. A violation of Article 3 of the International Covenant on the Elimination of All Forms of Racial Discrimination. Article 3 is a prohibition on racial segregation or apartheid. So we've been left guessing whether the court thinks it's racial segregation or apartheid or both, but we certainly know it's at least one of them. The court found that Israel is obligated to provide full reparation for its wrongful acts, including restitution and compensation. It emphasised that all countries must not recognise as legal any situation arising from Israel's illegal presence in Palestine. So that includes any recognition of Israel's purported sovereign annexation of East Jerusalem or settlements in the future, etc. This monumental decision was barely reported in much of the Western media. Now, of course, other factors played a role in October 7, including extremist ideologies, anti-Semitism, rejection of the idea of an Israeli state, and all of those things need to be equally fought against. Israel has legitimate security concerns that must be addressed, but they can't come at any price to the Palestinians, and they can't be done in the manner that thus far has not even ensured Israel's own security. It's been fighting endless wars for 60, 70 years. That's not a good national security strategy. Tellingly, Hamas did not exist before Israel's occupation in 1967. It was born and radicalised in the protracted failures to settle the dispute according to law and justice, and the multi-generational human suffering, humiliation, lack of opportunity, hopelessness and powerlessness that has afflicted the Palestinians. Given Israel's lack of a credible post-war plan for Gaza and Palestine more generally, and the US's default deference to whatever Israel seems to want, the mistakes, injustice and trauma of the past century look set to continue unless the severity of this crisis forces greater introspection and a rupture from the status quo of accepting what has become an indefinite Israeli occupation and previously creeping, now I'd say simply overt, annexation through the settlements. There are some tentative signs of hope, with some European countries breaking ranks recently to recognise Palestine as a state. Yet the United States and some allies like Australia refuse to recognise statehood, despite most of the world doing so. 139 countries, 72% of the world. That's more than recognise Western-backed Kosovo, which is only 115, or Taiwan, which is 0. Even Taiwan does not declare itself to be independent, yet the United States sabre rattles about its defence without providing any clear legal basis for defending what is considered a non-state territory under international law. Ideological defence of democracy may be morally appealing, but it doesn't square with the rules. Without a step change, injustice and perceptions of injustice will remain key drivers of radicalisation, violent extremism and terrorism into the future, causing insecurity for Israelis and Palestinians alike, and contaminating all manner of other international relations beyond the region. The current excessive response by Israel, much like the US overreaction after 9/11, may have, as the US Director of National Intelligence Avril Haines warned recently, quote, a generational impact on terrorism, not only in the region, but elsewhere. So to draw all of this to a conclusion, the dispiriting truth is the West does often contemptuously abuse international law. Perhaps no surprise. The West weaponizes international law in pursuit of its own political ends or as a cudgel against its adversaries. It ignores the law when it gets in the way of US or allied interests, knowing that geopolitical power confers impunity from enforcement. Western selectivity signals that international law is not law at all, just a smokescreen for power. Despite not practicing what it preaches, the West then seems surprised when its lectures about a rules-based international order, which an expression I don't use, by the way. I think international law has been around for 400 years. It's going to stick around for a lot longer. Rules-based international law is a bit of a thought bubble, which, I don't know, I give it a decade before the international relations people start talking about something else. When its lectures, anyway, about this order fall on deaf ears, or when non-Western states do not rally to its cause against Russia with sanctions or weapons or votes. The West's attitude weakens respect for the law everywhere. It invites other countries to play the same legal game. It's no accident that Russia cloaked its invasion of Ukraine in concocted legal justifications like self-defense, preventing genocide, or protecting Russian nationals. They learned from the West's legal acrobatics in Iraq, Kosovo, Guantanamo Bay, Palestine, all places where extremely novel and totally unreal legal arguments were tried to defend what were clearly violations. As power shifts to Asia, China too has learned from us that power lets you create rules to suit yourself and bend or ignore rules that don't. Now, obviously, not all violations of the same international rule are morally or politically the same. Russia's invasion of Ukraine is worse than NATO's well-intentioned intervention in Kosovo and worse than the US invasion of Iraq, which sought to topple a regime on a legal pretext, but not to swallow, the sovereignty of the country. They're nevertheless violations of the same, what we call fundamental rules of international law. The ground rules of a stable, mutually agreed world order. All unilateral breaches of those rules, without consequence, committed with impunity, weaken that order, respect for it, and the deterrent value of the rules to future aggressors. The stark contradictions between the US approaches to Ukraine and Gaza are also eroding confidence in the universal values championed by the post-war multilateral order, at a time when geopolitical power is shifting and transactional, non-ideological alliances are growing, from Russian influence in Africa or Chinese influence in many quarters. It's part of a larger critique unfolding about who shapes international rules and selects the causes that matter to the global order. As India's External Affairs Minister, S. Jaishankar, put it recently, quote, somewhere Europe has to grow out of the mindset that Europe's problems are the world's problems, but the world's problems are not Europe's problems. Why should Pacific states care about European and US concerns in Ukraine when the West does not care enough about their concerns for a fairer economic order, from trade to debt to development, or about meaningful climate change compensation and action to prevent their countries going underwater. None of this is to suggest that certain non-Western countries would necessarily respect international law as long as Western powers started doing so, but it would certainly increase the global social pressure to conform to the rules, raise the political and economic costs of violations, and likely induce more compliance than at present. Even the most powerful countries are sensitive to their international reputations. I've been in many meetings with senior government officials from the permanent five of all stripes who are surprisingly touchy and sensitive about global criticisms of their reputations. They are concerned about the material harm to their tangible interests that can often flow from serious reputational damage and ostracism. The job of international law, in the absence of a global police, is to continuously raise the price of non-compliance. Now, to some degree, international law will always be hostage to power and self-interest. It is decentralized. It is a developing legal system. It is created by countries in large part to serve their own interests, not necessarily the interests of other actors. It lacks an international police to compel obedience. It relies on countries acting in good faith, and lots of governments are not good faith actors. It relies on them doing the right thing, pressuring other countries to do the right thing, and uphold their legal bargains. As I mentioned, compliance is the hardest in the realm of high politics that concerns national and international security. Critical gaps and deficiencies in the international rule of law will remain, given the nature of the legal personality of sovereign states, that too few states are willing to cede more sovereignty to international institutions, enforcement, dispute settlement. Many states, most states, including in the West, prefer to preserve their less fettered political latitude in domestic and international affairs. It is sadly true, and I don't see this changing in my lifetime, that most international crimes will never be punished, and that's a fact. We have to be realists about what even advanced, well-functioning legal systems can achieve, and realistic about our expectations, and not too utopian. In many domestic legal systems, law enforcement is also weak, selective, arbitrary, corrupt, or ineffective. In a really strong legal system, comparatively speaking, like Australia, non-compliance with the law is endemic in many areas, and may meet limited tokenistic or arbitrary enforcement. Consider, for example, the millions of daily unpunished breaches of public health restrictions during the COVID-19 pandemic. That almost 80% of Australian drivers admit to breaking the speed limit when they drive, and most are never caught. The prevalence of tax evasion, the minuscule chance that sexual assault will ever be punished, certainly through a criminal conviction, or the drastic difference in access to justice, including in the courts, due to economic inequalities. On many measures, the Australian legal system is an utterly dysfunctional one, and yet we see it as a kind of gold standard when we talk about how bad international law is. In the same way, these are problems of law and social life and justice and politics generally, not just international law for all of its uniqueness. And like domestic law, most of international law works most of the time. You just don't see it because it's not a spectacular breach like the invasion of Iraq or the decimation of Gaza or October 7. Even when strong norms have been agreed or strong institutions established, they'll also only ever be as strong as the political and social customs in which they are embedded. Eric is here. I'm going into some jurisprudence here. Law is not autonomously authoritative, as many coups in many states, countries demonstrate. I'm soon to go to Niger, where, a bunch of soldiers just overthrew the government. And for all of the legal institutions, judges, constitutions, it meant nothing when guys with guns come through the door. Judges cannot stop governments of gunmen. even if they possess ostensibly binding jurisdiction to enforce laws validated by rules of recognition like constitutions, even if they've been around 100+ years like ours. In this sense, actually, international law has proved more stable and law-like than many national legal orders. Most countries are not like Australia. Most legal systems are actually pretty weak and fragile and have been for a very long time. So we are in, I think, a cycle of history. If you take the long view, international order, international law swings between utopianism and realism at different points. There was a kind of humanitarian upswing in the 1890s and early 20th century with the Hague peace conferences. That was smashed by the First World War. Out of its ashes came the utopianism of the League of Nations and the collective security system that it gave birth to. It was destroyed by the Second World War. The UN Charter injected human rights, self-determination, decolonization, a whole lot of new aspirational values. Cold War struck that down pretty quickly. 1990s, we got another upswing in utopia with the end of history and lots of peacekeeping and lots of excitement about multilateralism all over again. By the early 2000s, rising China, Russia, various failures of multilateralism had swung back many into the realist camp all over again. I think we're at a particularly low point at the moment, perhaps the early rather than the late 1930s, but it's never too late. International law is often battered, but it is surprisingly resilient. After every crisis that breaks the international order, and which international law was designed to prevent, states return time and time again to the promise of international law in the hope to pick up the pieces and to do better next time. International law appeals to radically different political orders for good reasons. Whether compliance is compelled by consent, self-interest, reciprocity, cooperation and coordination, stability and efficiency, alignment with national values, prospects for peace, prosperity, and morality that it offers, the list goes on. But only with less selectivity and more consistency and more accountability will international law no longer languish as imperial power masquerading as law, but fulfill its promise as a genuine means of holding states to the rules they created and solemnly pledged to obey, not least to protect human beings from predation, violence, abuse, and exploitation. If we expect others to be law-abiding, whether Russia now or China as it rises, we must also look unmasked into the mirror. Thank you.
Okay, we've got our two runners to hand out microphones for questions. So if you'd like to ask a question, just raise your hand.
I'm Karen von Strohkirch from International Politics at UNE. That was a fantastic lecture. Thank you very much. I was wondering if you think that the Russian and Israeli extreme breaches of international law that we're seeing in recent times, and the fact of the unwillingness or inability of the international community to hold them to account relates to their common status as nuclear weapon states, and also to a perception that with the prevailing regimes and leadership that their own willingness to use those nuclear weapons is unclear as to whether and under what circumstances they would do that.
Yeah, thank you. Look, I think the nuclear factor is a really big one. Certainly in the case of Russia, I mean, that's officially that's what the US has been saying. And you know, and you understand that reticence, right? I mean, intelligence assessments are a kind of probabilistic exercise. You rarely have any kind of certainty on it. I mean, is there an 80% chance or a 10% chance Russia would use nuclear weapons? Even if it's a 10% chance, is that one you want to risk, right? Given what those weapons can do. So look, there are certainly you know, domains where, you know, even international lawyers recognize law reaches its limits. I mean, states at some point have to make certain security judgments. They're the experts on the security front. You know, judges can you know, sometimes review those decisions in certain ways, but you know, ultimately it's a call states need to make, and preferably collectively. I mean, through the international system rather than unilaterally. I think that the calculus on nuclear has changed. I mean, with this recent incursion into Russia by Ukraine is certainly saying, look, we told you so. Russia didn't use nuclear weapons when we invaded Russia, right? So why have you been so concerned about taking the fight to Russia? And it does seem, you know, it is certainly hamstringing Ukraine to give them weapons, but say you can't use them in ways that would be effective or most effective. So look, I have no insight into where the US is on its thinking about that nuclear question. In Israel, there are different factors at play. I mean, it's no secret that the US has seen Israel as an important security partner in the Middle East, and there are, you know, all kinds of other geostrategic factors at play there, and there's Iran in the picture. I mean, you know, it's a bigger puzzle, but you know, you can still support Israel and support international law at the same time, right? And it's not being a friend of Israel to allow it to get away with violating international law. Yeah, I mean, I think you mean Arab states, neighboring Arab states, or
States around Israel are strained, I think, parts of nuclear weapon states.
Yeah, I mean, I think, yeah, and of course, there's the Iranian nuclear question in the mix on that front as well. My own view is, you know, Israel doesn't even need the nuclear weapons because its military is so much superior to all of the Arab militaries in the region. I mean, it's not like the much more touch and go 1948, 1967, 1973 wars. I mean, it's clear that Israel is militarily far superior than anyone, and probably all of them combined in the region. Plus, you know, October 7 happens, and it's also got 2 US aircraft carriers parked off its coast, right? I mean, it's fine. I mean, I know Israel. Some of the political rhetoric has talked about this being an existential struggle for survival. You know, if that was so, why is it then that Israel could repel the entire Hamas attack within 24 hours? That's not existential. I mean, Hamas had some, you know, fairly primitive rocket technology. They could make an incursion for some hours. They could, you know, murder 1,200 people, which is awful in these border areas. But Hamas was never going to, you know, occupy and overthrow the Israeli government. I mean, it's you know, it's been Gazans have been living in a cage under blockade for a very long time now. It's, you know, it's a small insurgent force of maybe 10, 15, 20,000 fighters. Most of them are now dead, probably. You know, it's not existential. Iran is obviously a different question, and certainly a nuclear Iran is a different question. But you know, it goes to the point of the 9/11 problem. You know, overreacting and responding to threats in an utterly disproportionate way, causing untold and unnecessary and illegal human suffering along the way. You know, Israel could have defended itself within the law. It would have meant taking higher Israeli military casualties, because instead of dropping a bomb and flattening whole areas of Gaza, you'd have to go street by street, and that exposes your forces to more risk. But that's what a a law-abiding, human rights respecting country has to do. I mean, you can't just sacrifice large numbers of civilians so that some more of your soldiers are protected.
Thanks, Professor, for truly fascinating talk. I'm just thinking about the universal jurisdiction that you say applies to war crimes and crimes against humanity, and normal principles of ancillary liability for accessories before the fact and aiding and abetting. And I'm just wondering whether some of the corporates who might be supplying some of the weapons, whether there are any potential legal avenues there, because deterrence doesn't seem to be working too well in terms of state actors and leaders.
Yeah, it's a great question. And so there's no corporate liability before international criminal tribunals, for example, like the International Criminal Court. But under domestic universal jurisdiction, it would then depend on, what is the scope of corporate criminal liability generally and how that fits with whatever is the international crimes legislation. There's certainly a bit of a movement on that front in some other contexts. So a good example is the French cement company Lafarge, which was convicted of or pursued in the French courts for terrorist financing crimes offences, because it was paying off ISIS so that its trucks of cement, goods, etc., could still trade in ISIS-controlled Syria. So it certainly, it's part of the movement for business and human rights to have that kind of hard edge of corporate liability on it as well. It then depends on, how those in-court offences are framed, and they're different in different, civil and common law jurisdictions, and there's no kind of uniform international universal jurisdiction in domestic courts on that question. I mean, aiding and abetting, it depends how wide or narrowly those offences are cast in terms of the obligations on companies. Conspiracy offences are another one that are sometimes used as well. One of the reasons why countries have increasingly prosecuted terrorism offences instead of international crimes in places where both are happening, whether it's ISIS territory or Gaza or whatever, is because terrorism offences have a lot more what we call preparatory offences. So you don't have to show attempt or conspiracy or aiding and abetting. You can just show that someone was a member or associated with or recruited for or trained with, etc. So you don't have to show that anybody contributed to the violent action, at the end of that chain of causation. Even I just saw last week, the US has indicted the senior Hamas leaders for the October 7 attacks, but only for a series of US terrorism offences under, applying universal jurisdiction to them, even when they kill foreigners and Israelis and not just Americans. Hasn't laid any war crimes charges, which to my mind is, and this is a bit of a debate at the international level, it doesn't do justice to the victims, right? Because, call it for what it is. It's a war crime. It's a crime against humanity. Those are international crimes, have been for the last 70, 80 years. Terrorism, there's no legal definition internationally. There's no agreed international crime of it. It's just a nasty, but still a national crime. And I think it does a disservice to victims to under-prosecute or to under-label symbolically what they have been victims of, right? Now, if you can put them in jail for a very long time for terrorism, well, that serves purposes of punishment and deterrence and incapacitation and all those kind of criminological goals as well. But you're still missing that expressive function of international criminal law, which I think is also important.
Just a question online. So in simple terms, what was the effect of the Balfour Declaration?
I might plead the fifth on that one. Yeah, look, what I would say is Yeah, look, I'm not going to do justice to the history of the Israel-Palestine dispute in a couple of minutes. It was a political statement by the British government. I mean, that's happy to say that. In terms of legal effect, I think it's a different story. One of the things about the tragedy in all of this is that a negotiated solution was there, right? I mean, there was a partition plan which the UN eventually adopts, or a version of it. Israel then, unilaterally preempts the outcome by just declaring itself a state, and then the Arab states unwisely invade. But it never played out, as was intended. One problem from the Palestinian standpoint is that even though it was endorsed by the UN in 1948, that wasn't a fair plan and there were good reasons why the Arab states rejected it, because it gave way too much territory, allocated way too much territory to the future Israeli state relative to population and prior patterns of settlement, bearing in mind that the Jewish immigration was pretty recent and pretty large numbers. And so, why would they accept something which is clearly not fair? The war breaks out. In the course of that war, Israel then captures more territory again. So, the state of Israel does not follow the partition plan. I mean, it includes, for example, Beersheba, where Australians fought a great battle in 1917. There's an Australian institution that has a thing called the Beersheba Dialogue between Israel and Australia every year or every other year, as if that was always part of Israel. I mean, actually, it was an Arab town. It was depopulated of Arabs in the course of that war, and Israel's claimed it ever since. That was never planned, even in the excessively generous partition plan. The other point, and this goes to the root causes I talked about. You'll always hear Israel saying, we've offered the Palestinians a state so many times, and they've unreasonably rejected it every time. Don't take it from me. Take it from a guy who was at the center of this for many years, former Secretary General Kofi Annan, who in his book says Palestinians have never been offered a deal which complies with their rights to self-determination under international law. They're always, it's the same deal being offered that, Russia would offer in a peace negotiation. We'll stop fighting as long as we can keep some territory. I mean, that's essentially what Israel has been saying forever. It's clear they will never evacuate 700,000 settlers. It's not like 15,000 settlers in Gaza, where at some cost that was possible. It will be part. Most of that will be part of a future solution in clear violation of international law, the Fourth Geneva Convention, the war crime of transferring your population into occupied territory, in breach of the right of self-determination declared twice in 2 judgments of the International Court of Justice, and the US is fine with that, it seems. So it's hard to talk about commitment to a rules-based international law order when that is your position on an issue like that.
Any other questions here? Because I've got this one.
As somebody who used to live in Niger, I can't resist asking you what you're going to try and do in Niger.
Yeah, so as a UN Special Rapporteur, we do what are called official country visits, where we go for a couple of weeks and do a kind of deep dive into their counter-terrorism laws, institutions, security, intelligence, military, police, border personnel, etc. And we report on it to the Human Rights Council. So it's a kind of fact-finding exercise to shed light on what's going on. Yeah, I was going to say off the record, but this is online. Is this being recorded as well?
It's being recorded.
Okay. Delighted Niger has consented. Niger is obviously facing an incredibly serious jihadi threat. which is spilling over into a bunch of its neighbours now as well. It's politically complex because, this is no secret. There was a military coup. The French were expelled. The African regional partners have, they've left ECOWAS. They've invited Wagner fighters, whatever you want to call them, that's not working very well. So it's a tough environment at the moment. So my job is to help them to do better in terms of complying with human rights, humanitarian law, protection of prisoners, assistance to victims, and how you help the victims of the jihadis as well, because it's part of the mandate. I'll keep you posted if I come back alive in December. Yep.
Right. I'll amalgamate a couple of questions that are online. How do we enable consistency to be applied internationally in the rules? And is there any optimism?
Consistency, it's as I mentioned, so it's a decentralized international order. The UN gets blamed a lot, and from inside the system, I can tell you there are lots of failings in the UN, but the biggest failures are because of the decisions member states make in curtailing what the UN can do. Everything starts at the national level. Anything any of us can do to encourage our own governments to push to uphold international law at the international level through all available means, we should be doing that. Whether we're pressuring our MPs to stop arms exports to countries which are violating international law, or getting them to vote the right way in UN General Assembly votes, or getting them to support litigation in the international court. That's another story I'd mention. When it comes to Myanmar, 30 plus Western and other states have intervened in that case, accusing Myanmar of genocide against the Rohingya. Lots of Western states have intervened in cases in international tribunals in favor of Ukraine against Russia, but virtually none have gone anywhere near the cases involving Israel. And if they have, it's to argue that Israel should not be held accountable in those institutions. So I think foreign policy is distant and aloof from most voters' minds, to be sure. There's not a huge foreign policy constituency in any country, including Australia. People don't vote. People vote from the hip pocket, cost of living, education, healthcare, all of that. They don't vote on, most of the time, whatever our foreign policy position might be on Sudan or wherever. I do think the Gaza conflict at the moment is a bit different, because it has agitated and polarized, but even still, it's a pretty small minority of interest groups and sympathizers who would flip a vote on the basis of the very little capacity Australia has to influence what happens in the Middle East. But nonetheless, engaging with governments to do better, to show that Australians do care about foreign policy choices, I think is something we have to do. On optimism, I think, as I mentioned, I think that the story on Ukraine is a good one. Short of starting a nuclear war, we are doing everything available. It's not enough, and it's frustrating, and we all wish it was faster and would work better. But in some ways, I think that is quite an optimistic story. It's not the high point of the first Gulf War, but then Ukraine also doesn't have oil in the way that Kuwait has. So that also wasn't purely disinterested altruism either.
I have time for one more question. So.
If I can project my voice. I don't know if you're aware, but we have a small population of Yazidis, refugees in Armidale, and we recently attended a memorial service in memory of the 2014 genocide in Sinjar, northern Iraq. And at that, one of the Yazidi speakers mentioned that the investigating body, UNITAD, was to close down this month. And I did some research and found that it was actually closed down by the by the Security Council. And but the problem is with that is that all the evidence they've collected is to be handed over to the government of Iraq, and who will supposedly proceed with prosecutions. But it has been offering amnesties to some ISIS people as they come along, and it's very difficult to know how guilty people who were dragooned into ISIS might have been, or whatever. But I was wondering if you could explain why the Security Council would have closed it down at this stage, because a lot of the evidence is could be lost, or and things that they were doing, like excavating mass graves, which would help people to identify members of their family, won't continue. And I was just wondering if you had any idea why it was closed down.
Yeah, it's a great question, and it did amazing work, and there have been some convictions in various countries based on the evidence it collected. Look, I think it's a bunch of reasons. I think it's time elapsed since it happened, significant devotion of resources thus far, and a lack of willingness, given competing priorities and on all fronts, from Gaza to Ukraine and Sudan, and so that kind of waning attention span problem. It also, was naturally going to conclude at some point, because it was only, I say, giving it full credit for what it does, but only in the sense of it was an evidence collection body. It wasn't a prosecutorial tribunal or anything like that. So its purpose was to collect, store, and then at some point close shop and hand over those records, for whoever wants to use that forever after, whether that's domestic or international tribunals. And by the way, I should say everything tonight is in my academic capacity as a professor, not as UN Special Rapporteur. There is one country already trying to get me sacked, so I'm being careful. Iraq, I would say, has made progress in some ways post ISIS, but the UN has really serious concerns about the fairness of trials, about the application of the death penalty, about the conditions of detention, in some cases about alternative justice systems through tribal justice systems, and that rehabilitation reintegration process for former ISIS fighters that is sometimes devolved to the tribal level. So look, I share many of those concerns, and that was, a really terrible suffering that the Yazidis went through. I would just mention, because this is a file I work on very closely at the UN, and it goes to the point earlier about, what can all of us do? There are significant numbers of Australians sitting in arbitrary, indefinite detention in northeast Syria, in detention camps for the families of foreign ISIS fighters. Australia is not bringing them home. We brought some home a couple of years ago. It was then splashed all over the media. Neighbours don't want to live next to terrorists. Government got cold feet. Nothing's happened ever since. These are Australian children. They're at serious risk of disease, including tuberculosis, malnutrition, serious violence from radical elements in the camps. And Australia, from what I can tell, has washed its hands of them for the time being. They're held in detention by a non-state armed group, the Kurds. They're not even a country, a government. And so Australia's solution, and the world of other foreign nationalities, and there are 50 or 60 other foreign nationalities represented there, the solution is to expect a non-state actor, which isn't recognised as a government by the international community, to indefinitely detain thousands of ISIS fighters in the middle of a civil war where they're being bombed every other day by Turkey, attacked by the Syrian Assad regime as well, and fighting ISIS remnants across the desert. They're expected to run detention facilities to international standards for tens of thousands of people, including women and children, on a shoestring in incredibly insecure conditions. And that's our solution. Now, that is a total failure of multilateralism and burden sharing, and frankly, being a decent Australian and caring for Australians. The children of ISIS fighters are victims. They didn't do anything wrong. They didn't choose to go to Syria. They didn't choose to murder civilians. And from what I can tell, Australia doesn't seem to think that matters very much. So, write to your MP and get them to bring them home.